Good afternoon. My name is Martin Palouš. I am a director of Václav Havel Program for Human Rights and Diplomacy at Florida International University. And this program is part of our joint project with Inspire America Foundation. The director of that foundation, Marcel Felipe, is with us, and he will be also serving as a moderator for this panel. The Initiative for Democratic Economic Alternatives for Cuba, Ideas for Cuba, is dedicated to the research, exploration, and dissemination of alternatives for Cuba's future as it transitions towards a more democratic system. Today's topic is law. It concerns models for implementing Cuba's future transition to democracy, reforming the Cuban legal system. We have here with us a couple of participants at this panel, so I will introduce them right now and thank them for their participation. We have Jason Poblete, attorney based in Washington, and active in Global Liberty Alliance Foundation. We have Professor Jose Gabilondo, professor of law at FIU College of Law. And we have also Santiago Alpizar, attorney here based in Miami, co-founder of Cuba Demanda Foundation. And last but not least, we have the most distant participant in our debate, Pavel Telička, who is sitting right now in Prague, joining us. He's a former EU commissioner and vice president, a former vice president of the European Parliament. And he has been working with us for a while. So certainly he's an important contribution to our efforts. So Marcel, you are co-moderator of this panel, and we are working together, our program and your initiative, your Inspire America Foundation. So please say a few words at the beginning.
Thank you, Martin. I appreciate your introduction. I must say Martin is somewhat modest when he says he's a director of the Havel Center at FIU. Martin was part of the Charter 77, and he was the Czech Republic's ambassador to the United Nations and to the US. So it's a privilege to co-sponsor this program with him. Inspire America, as many of you know, is an organization that works to promote change in Cuba, a complete, more than a transition, I would say a complete end to the system and a brand new democratic system, very much the way that Martin, Václav Havel, and so many others did in the Czech Republic and in Eastern Europe. Ideas, specifically the Ideas Project, which is the Initiative for Democratic and Economic Alternatives for Cuba, it's a slightly different version. We're not here to try to figure out what are the strategies to bring about regime change. For example, Cuba Demanda has their strategy of using the legal system in Cuba against it. There's many different strategies, there's many different ways. That's not what Ideas is about. Ideas is if and when there is regime change, if and when, whether by coup, whether by decision from the top, however it comes down, there is a consensus that says, let's transition to democracy. What are the steps that we should be taking at that particular moment? And both in the economic sphere, and we're working with Columbia University and developing an excellent report that will be out at the end of the summer, perhaps at the beginning of the fall, with some of the best economic minds in the world to create sort of a Cuban Marshall Plan, a Cuban reconstruction. There is an international component that's got to review Cuba's reinsertion into the monetary fund, into all the international agreements, how to end the bad agreements, for example, the agreements by which Cuba exploits Cuban doctors, agreements with Venezuela, with Russia. But the third and perhaps most important of all the components is this one that we're going to discuss here today, is the legal system. There's a saying that there's nothing more cowardly than $1 million. You're basically not going to get any investment if you don't have a clear set of rules upon which to build on. So the question is, rather than give an explanation of what I would propose, although later I will participate as a panelist myself discuss the one document that has sort of the main transition document that has been adopted by most of the opposition groups inside and outside of Cuba, the Acuerdo por la Democracia, led or formulated primarily by former member of Congress, Lincoln Diaz-Balart of the US Congress. But the questions are more important than any particular document. And those are, once you do this, I think there's a consensus based on Western philosophy of government that a legitimate government gets its authority from the consent of the government. So therefore, there must be perhaps a brand new constitution drafted, approved by the people, but drafted by a duly elected constitutional assembly. That's a relative consensus, I think, for most observers. The question is, how do you get there in the interim? Do you continue, for example, I'll throw three options to discuss. Do you continue with the existing communist constitution during that transition period, but similar to the Czech model, you would adopt the UN Declaration of Human Rights and say anything that's inconsistent with this in the communist constitution is automatically null and void, and that is your basis upon which to go through your transition and get to your constitutional assembly that then comes up with a new constitution? Do you go back and say, well, we can't begin from a rotten tree? The Constitution of 1940 was the last democratically promulgated constitution. That should be your transition document upon which you build your new constitutional assembly. Is there another option that we haven't, that's neither one of those two, perhaps from one of the other East European experiences? What I think is clear is that regardless of which one of those two or perhaps other alternative paths we take, there are certain things that have to be put in practice immediately so that any election to the Constitutional Assembly itself has the guarantees of the legitimacy of democracy, such as, and these are included in the Acuerdo por la Democracia, freedom of speech, freedom of assembly, freedom of the press, freedom to form political parties. Those, I would say, are the core rights. You may add to some of those, even during the transition period, issues such as control of the media or equal access to the media for purposes of the public discourse, depoliticization of the judiciary, even during that transition phase, issues of private property during that transition phase. Some of those may be more apt to be dealt with at the Constitutional Assembly itself, and just having the basic core rights during this transition period to ensure a proper election process. But those are the issues, those are the questions that we seek to answer to be able to incorporate. By the way, all of these would be incorporated into one final report early in this fall that will have that economic Marshall Plan, but also these recommendations. And it's not going to be a specific set of recommendations, you do this, but more of a menu of options, so that on day one, we are not starting to do this exercise, but on day one, those leaders have a set menu of options to choose from. Thank you.
Marcel, thank you very much. So let's start. But we'll start with two voices of people who cannot be with us at that moment. First one is Rene Gomez Manzano, who sent us this message yesterday from Havana. Rene Gomez Manzano is lawyer and constitutional expert. He's a former political prisoner. And by the way, when Czech Republic took the action in Geneva supporting the human rights defenders in Cuba, proposing a resolution just to take that fact into consideration, Rene was one of those four co-authors of Patria para Todos documento. And so we had Rene Gomez Manzano certainly on our list from the very beginning. He's a co-founder of group Corriente Agramontista, group of Cuban lawyers. So that's what Rene had to say to us yesterday. Please, let's give him a floor.
Buenas tardes, mi nombre es René Gómez Manzano. Quiero ante todo dar las gracias a esa prestigiosa institución, la FIU, y en particular al profesor Martin Palouš, que gentilmente me ha invitado a participar en este coloquio. Quiero referirme ante todo al primer punto planteado, previsto para este conversatorio. Me refiero al estado actual del ordenamiento jurídico cubano. Yo creo que lo primero a señalar en este sentido, algo esencial, es decir, la existencia de una nueva constitución que entró en vigor el pasado año. Constitución a la que yo doy el nombre de Constitución Raulista, para diferenciarla de las otras superleyes que fueron dictadas en tiempos del señor Fidel Castro y que yo llamo constituciones fidelistas. Entonces, ya situados en esta nueva constitución que está vigente desde hace un año, lo primero que hay que, creo yo, señalar es el mantenimiento en ella de disposiciones antidemocráticas. Y de modo especial quisiera referirme al nuevo texto del artículo 5 de esa Carta Magna, donde por primera vez en la legislación, en el derecho positivo cubano, se plantea que el Partido Comunista es el partido único. Es decir, siempre lo fue desde su surgimiento, pero la primera constitución en donde se plantea esto es la Constitución Raulista, precisamente, el carácter de partido único del Partido Comunista de Cuba. Y en segundo lugar, señalar también una nueva característica que es el reconocimiento formal de los derechos humanos. Esto se ha hecho, por supuesto, no con el propósito, estimo yo, de brindar mayores derechos a los ciudadanos cubanos, sino con el fin de, esto se ha hecho de cara a la comunidad internacional, para presentar un mejor aspecto del régimen en este sentido. Y bueno, hay que reconocer que ciertamente lo lograron, es decir, toda la sistemática de esta constitución en lo tocante a los derechos humanos es mejor, menos mala, para ser más exacto, que la de las constituciones anteriores. No obstante, es bueno señalar una cosa: el instrumento esencial en el sistema antidemocrático establecido en Cuba no es la Constitución, sino la ley electoral. Es decir, el texto legal fundamental en este sentido es la ley electoral. Por ejemplo, la disposición totalmente antidemocrática que establece que el número de candidatos, digamos, para diputados sea igual al número de los cargos a cubrir, es decir, que no hay escogencia ninguna del ciudadano, es precisamente la ley electoral quien lo dispone. La Constitución no dice nada al respecto. Pudiéramos citar también otro ejemplo, por ejemplo, la circunstancia de que los exiliados cubanos no voten, no tengan derecho a votar en las elecciones. Votan los cubanos que están en el extranjero, pero en misión, los diplomáticos, los enviados en alguna tarea por el gobierno, pero no los ciudadanos que han emigrado del país. Esto también es un resultado, es decir, algo que está plasmado en la ley electoral, no en la Constitución. Entonces yo digo que es necesario, para iniciar el proceso de democratización de Cuba, reformar sí, ante todo la ley electoral, pero reformar también la Constitución. Me remito, mejor dicho, en este sentido, a mi trabajo 10 posibles aspectos jurídicos de la transición democrática, que aparece en mi libro Constitucionalismo y Cambio Democrático en Cuba, que fue publicado por la editorial hispano-cubana en Madrid en el año 2007. Allí yo hago referencia a una serie de preceptos constitucionales que deben ser modificados para que la Constitución pierda, o por lo menos empiece a perder ese carácter antidemocrático que tenía en aquel momento, ¿no? Entonces, claro, cito los preceptos de la Constitución que regía en aquel instante. Al referirme a la de ahora, la Constitución Raulista de 1919, pues yo citaría, por ejemplo, como artículos que sería indispensable modificar: el 5, el 6, el 13, inciso A, el 18, el 19, el 32, inciso B, el 42, en la parte en que permite discriminar a los ciudadanos por sus ideas políticas, es decir, entre los criterios prohibidos de discriminación no están las ideas políticas. El artículo 55, que plantea que los órganos de prensa sean propiedad socialista de todo el pueblo, es decir, un eufemismo para decir que es el gobierno quien controla la prensa. El 73, etcétera. Yo creo que esto sería el primer aspecto a señalar en lo tocante a ese primer punto de los temas que ha sometido a nuestra consideración el distinguido profesor Martin Palouche. para terminar, quisiera referirme al tema de la situación actual de Cuba desde el punto de vista del derecho internacional. Ya en este contexto, pues es muy frecuente que las personas se mencionen y hagan hincapié en los pactos de la ONU, es decir, el Pacto de Derechos Civiles y Políticos y el Pacto de Derechos Económicos, Sociales y Culturales. Estos, como se sabe, fueron firmados por Cuba, el representante del gobierno cubano, que en aquella época era el señor Felipe Pérez Roque, aún no había sido defenestrado, hace años. Esto se firmó hace años, pero hasta el día de hoy no se ha ratificado por parte del gobierno cubano ninguno de estos dos pactos internacionales. Es importante, estimo yo, insistir tanto por los ciudadanos como por la comunidad internacional, insistir para que el gobierno cubano ratifique estos documentos, deposite los instrumentos de ratificación de ellos. Pero yo quiero hacer hincapié en otro documento que, a diferencia de estos pactos, sí tiene vigencia para la República de Cuba, y que es la Declaración Universal de Derechos Humanos. Como se sabe, la Declaración Universal de Derechos Humanos, aunque con otro nombre, porque en aquella época se llamaba de Derechos del Hombre, fue aprobada en 1948. Se trata de una recomendación de la Asamblea General. Sin embargo, a pesar de este carácter inicial que tuvo, a pesar de que en un comienzo ella no tenía un carácter vinculante, con los años sí lo ha ido adquiriendo, y en la actualidad, estimo yo, y lo digo no porque lo piense solamente yo, sino porque es el criterio coincidente de la generalidad de los estudiosos del derecho internacional, que la Declaración Universal de Derechos Humanos en los momentos actuales y desde hace años ya sí tiene carácter vinculante. Quisiera referirme en este contexto a un trabajo de mi autoría, que tiene el título de La actual naturaleza jurídica de la DUDH, que fue publicado en el número 10 del Boletín de la Corriente Agramontista, la organización de juristas independientes que me honro en presidir, en diciembre de 2012. Y para los que quieran entrar y localizar el documento y leerlo, pues pueden hacerlo a través del blog de nuestra organización, que es www.agramontista.blogspot.com. Decía que todos los internacionalistas coinciden en el carácter vinculante que actualmente tiene la Declaración Universal. Para esto, lo que sí no hay unanimidad es en por qué motivo, es decir, qué es lo que le ha dado este carácter vinculante a ese documento. Unos dicen que se trata es decir, que la Declaración Universal contiene una interpretación original de los preceptos de la Carta de las Naciones Unidas, donde se menciona la frase derechos humanos. Es decir, en varios de los preceptos de este documento fundamental de la comunidad internacional, ¿no?, después de la Segunda Guerra Mundial, la Carta de las Naciones Unidas, en varios de estos preceptos se hace alusión a los derechos humanos. Entonces, ¿por qué entender por derechos humanos? Entonces, esta serie de internacionalistas pues aduce que la Declaración Universal pues constituye una interpretación original de ese término. Y entonces nos dice qué es lo que debemos entender por derechos humanos. Otros aluden a las constantes y reiteradas los reiterados pronunciamientos que han hecho los estados a través de sus respectivos gobiernos, por ejemplo, en declaraciones internacionales de gran relevancia. En estos documentos que han sido firmados reiteradamente por distintos miembros, la generalidad de los miembros de la comunidad internacional, se hace alusión y se menciona expresamente la Declaración Universal de Derechos Humanos, y se hace alusión a la necesidad de observar sus preceptos. Entonces este grupo importante de internacionalistas considera que es por esa vía que la Declaración Universal ha adquirido ese carácter vinculante. Por último, hay otro grupo de estudiosos del derecho internacional que consideran que las disposiciones de la Declaración Universal son constituyen normas del derecho consuetudinario, invoca en este sentido el artículo 18 del Estatuto de la Corte Internacional de Justicia y consideran que, bueno, que esto, por esta vía es que adquirió este carácter normativo, la Declaración Universal de Derechos Humanos. Pero lo importante, repito, es que todos, aunque los argumentos del por qué se ha llegado a ese punto sean diferentes, todos reconocen que se trata de una norma vinculante del derecho internacional actual. Además, otra cosa muy importante, y es que el gobierno castrista en ningún momento ha negado que la Declaración Universal de Derechos Humanos tenga ese carácter normativo, ese carácter vinculante. Y entonces, ante esta realidad, yo digo que con respecto a qué actitud asumir por los miembros de la comunidad internacional que mantienen relaciones con Cuba, incluyendo de modo especial a la Unión Europea, yo creo que lo básico es, en los documentos que se firmen con la parte cubana, es hacer alusión, incluir allí la Declaración Universal de Derechos Humanos y hacer constar en cada uno de estos documentos la necesidad de que la parte cubana, de ambas partes, ¿no? Pero bueno, específicamente de la parte cubana también, que observe los preceptos contenidos en este importantísimo documento del derecho internacional. Hasta aquí mi exposición. He tenido mucho gusto en hablar para ustedes. Soy René Gómez Manzano. Muchas gracias.
Now, what will come now is the second contribution to our discussion from the outside. Professor Rogelio Pérez Perdomo is professor of law at Universidad Metropolitana in Caracas in Venezuela. He frequently visits the United States, but right now he's in Caracas. I'll ask Ofelia if she can give him her voice and read what he sent us yesterday. Ofelia.
Good afternoon to all. My name is Ofelia Riqueses, and I work at FIU's Václav Havel Program for Human Rights and Diplomacy. I will be reading the words of Professor Pérez Perdomo. As Professor Palouche said, he's a renowned legal scholar, and he has written profusely about the rule of law and the elements required for a democratic transition in legal terms, especially in the context of Venezuela. Following is his statement. La transición a la democracia y al Estado de Derecho en Venezuela. Es bien conocido que en Venezuela estamos en una dictadura que sufrimos desde hace 20 años y que ha intensificado la represión y la masiva violación de derechos humanos desde 2014. La Alta Comisionada por los Derechos Humanos, la Comisión Interamericana de Derechos Humanos, la Organización Internacional del Trabajo y muchos otros organismos han documentado la situación que vivimos. El Rule of Law Index nos ha puesto en el último lugar de los 128 países que ha analizado. Hemos ostentado ese lugar por varios años. El régimen no solo ha atenazado el sistema jurídico, también destruyó el económico. Un número elevado de venezolanos ha tenido que huir del país. No es fácil dar cifras precisas, pues además de cambiantes, hay distintas maneras de contar. El estimado es que entre el 15 y el 20% de la población se encuentra fuera del país. Organismos de Naciones Unidas han advertido que el país está al borde de una hambruna. Es un descuido del régimen que permitió una elección democrática nacional. La oposición logró el control de este importante organismo. El Tribunal Supremo, realmente renovado y reforzado con leales partidarios del régimen, se encargó de anular todo lo que producía la Asamblea y dejarla sin atribuciones. Para completar el panorama, el régimen se dotó de otra asamblea, la Asamblea Nacional Constituyente, que asumió poderes supremos sin límites constitucionales. Nicolás Maduro también se hizo reelegir por república en un proceso electoral cuya falta de integridad fue rechazada por la mayoría de las democracias del mundo, que desconocieron su resultado. La elección de la Asamblea Nacional Constituyente y la del presidente no fueron democráticas, y los partidos de la oposición no concurrieron. En enero de 2019, el presidente de la Asamblea Nacional, Juan Guaidó, asumió la presidencia provisional de la República. Los jerarcas del régimen están buscados en Estados Unidos y otros países por narcotráfico. Más de 50 países han reconocido a Guaidó como el presidente legítimo, pero en la práctica Maduro sigue en el Palacio Presidencial y comandando a los militares y los policías. Este es un brevísimo resumen de la situación venezolana. Recientemente el secretario de Estado Pompeo le pidió al personal diplomático que se preparara para regresar a Caracas, pues el cambio del régimen estaría próximo. Muchos académicos venezolanos han percibido la inminencia del cambio desde 2015 y se han esforzado en pensar en la transición. La Universidad Católica Andrés Bello publicó en 2018 un impresionante volumen sobre las distintas tareas de la transición a la democracia. El volumen tiene un capítulo largo sobre el Estado de Derecho que analizó los cambios que hay que hacer en la Constitución, la legislación y la organización institucional del país. El 5 de febrero de 2019, la Asamblea Nacional aprobó el estatuto que rige la transición a la democracia. El estatuto es un documento colectivo aprobado por los distintos partidos de la oposición. Acá solamente anoto que los partidos prefirieron partir de la Constitución vigente y no proponen cambios constitucionales o legislativos, sino acciones institucionales que permitirían tener unas elecciones presidenciales y un pleno restablecimiento de la democracia en el tiempo máximo de 1 año. Aún más recientemente, en abril de este año, el Institute for the Integrated Transitions publicó un volumen para una transición integral e incluyente en Venezuela, con un capítulo sobre el Estado de Derecho. Asimismo, en la Escuela de Derecho de Stanford está activo un Policy Lab sobre la transición y Estado de Derecho, muy concentrado en el tema de los cambios en el sistema de justicia. Lo dirigen 2 colegas venezolanos. Desde distintas disciplinas, los académicos venezolanos hemos pensado sobre el tema derecho, no estamos completamente de acuerdo, no es de extrañar, y no solo por la naturaleza del tema, sino porque los abogados tenemos la costumbre de disentir. En resumen, no ha habido ausencia de reflexión sobre la transición a la democracia y el Estado de Derecho, pero en la práctica la transición no ha tenido lugar todavía. En esta nota no deseo plantear ninguna crítica al trabajo de mis colegas y compatriotas, por quienes tengo el mayor aprecio. Las reformas a la Constitución y a las leyes que plantean me parecen acertadas, y los pasos para la transición a la democracia me parecen sensatos. Sin embargo, mi pregunta es, si se realizan esas reformas y se dan esos pasos, ¿tendremos un Estado de Derecho? Mi respuesta debe ser matizada. Sin duda tendríamos una buena infraestructura normativa y probablemente un grupo de personas calificadas dirigiendo el Estado, lo que sería importante. Pero no es seguro que el país comience a funcionar conforme al modelo del Estado de Derecho. Eso requiere explicación. El Estado de Derecho es un modelo normativo, no una especie de nirvana que podamos alcanzar y permanecer en él. Algunos países se acercan al modelo normativo más que otros y esto es lo que nos permite construir un índice. La construcción de ese índice es laboriosa y el resultado no es perfecto, pero la idea central me parece correcta. Los países pueden ser clasificados por su cercanía o lejanía con el modelo normativo del Estado de Derecho. Además, es importante destacar que la posición en la clasificación no depende de la Constitución ni de las leyes, ni de los arreglos organizativos, sino de la conducta de los gobernantes, jueces y demás operadores del sistema, incluidos policías y guardias de prisiones. Es decir, de cómo opera el sistema político jurídico en la realidad. Por supuesto, también la conducta de los ciudadanos es importante. El Estado de Derecho no se decreta. La Constitución de Venezuela, de 1999, define al país como un Estado social y democrático de derecho y de justicia. También establece las afirmaciones más enfáticas de garantía de la legalidad y de los derechos humanos. Todo esto fue convertido en papel mojado muy rápidamente por los mismos que escribieron la Constitución. He escrito en contra de lo que he llamado el legalismo mágico, la idea muy aceptada entre los abogados de que cambiando la Constitución y las leyes se cambia la realidad. No es este el lugar de insistir en mi crítica, pues creo que es fácil constatar que las leyes no tienen ese poder mágico. Cuando afirmo que nos acercamos o nos alejamos del modelo normativo del Estado de Derecho y que ello es un proceso cultural, debo insistir primero en que la cultura es un conjunto de actitudes, opiniones y valores que no están dadas como fenómenos naturales. Al contrario, lo cultural es siempre construido. La cultura puede ser intervenida. Los publicistas lo saben y siempre intentan modificar nuestras valoraciones y hábitos de consumo. Por supuesto, no siempre lo logran porque los procesos culturales son complejos, pero ciertamente los cambios de legislación no cambian la cultura. En segundo lugar, sabemos que la educación formal tiene importancia en la formación de valores y actitudes. También sabemos que las escuelas de derecho son importantes porque allí se forman las huestes del Estado, expresión de Gaitán Borges, y que en líneas generales han hecho un mal trabajo porque desde hace tiempo han optado por ser técnicas, es decir, por transmitir información sobre la legislación o las competencias más instrumentales que necesitan los profesionales. La consideración de los valores del derecho y la formación de actitudes que permiten que funcione el Estado de Derecho ha sido descuidada cuando no olvidada. Por supuesto, hay excepciones. Los profesionales del derecho solos no pueden construir el Estado de Derecho. La educación cívica también ha sido descuidada en la mayoría de los países. Esto incluye la educación en historia, que es tan importante para la formación de la idea del país. En Venezuela, un curso de educación cívica fue sustituido por una educación premilitar en la década de 1980. Y para alarma de mis amigos de la Academia de la Historia, los nuevos libros de historia insisten en presentar el país como un continuo campo de batalla y destacar la figura de Chávez. Por último, la educación informal es probablemente aún más importante. El ejemplo de los gobernantes y de los jueces es fundamental. José Juan Toaria estudió la transición del franquismo a la democracia y el Estado de Derecho en España y dio importantes decisiones judiciales que, en sus palabras, reinauguraron la visión del Estado y del derecho entre los españoles. En este sentido, y como profesor de Derecho Comparado, expresar mi preocupación por la conducta de gobernantes, aún en países tradicionalmente democráticos, que lo ponen en peligro. La construcción del Estado de Derecho requiere de un esfuerzo permanente. Prestar atención a la cultura jurídica y política y tratar de construir el Estado de Derecho a partir de la formación de quienes van a manejar el Estado y la política, y aún más a los ciudadanos, requiere un esfuerzo sostenido y poco visible. Además, a los abogados no se nos entrena para intentarlo. En cambio, cambiar la Constitución y las leyes es más fácil y glamoroso. Por eso creo que el legalismo mágico prevalecerá. That is the end of Professor Pérez Perdomo's statement. Thank you to all.
Okay, thank you very much, Ophelia. And right now, I would also ask, I would thank the participants for their patience and ask right away Jason Poblete to start with his remarks. Jason.
Thank you, Mr. Ambassador, and thank you for having me join this great group from around the world and around the country. I think right off the bat, René López Manzano pretty much set the context for us where the political change is essential. A lot of the rule of law challenges that Cuba is going through, and that I have seen close up over the past few years working with independent lawyers in Cuba and victims of human rights abuses, it's pretty clear that there are many challenges. And I'm just going to outline a few of them and give us a little bit of history for context. And Marcel alluded to some of this. You know, in the US, we have caked into our system a condition for the easing of the sanctions, a two-step approach where we will look to see a series of variables. And one of them, of course, to find a transition government that allows us to ease some of the sanctions, we include, since 1996, a move toward an independent judiciary. But I think it's much more than that. And when these laws were crafted, it was the great work of many people who we all know. We're setting these standards as guides, but ultimately the most important players in this are the people of Cuba, the independent lawyers, the people on the ground. Those are the people that we need to look toward. And we stand there to help them if they ask for that help. And I think that's my first takeaway from interacting with so many independent lawyers in Cuba, some, frankly, that have come out of that system who left because they just did not want to practice law in the state system. A lot of people don't know this, but the state system in Cuba is the only legal system in Cuba. So if you're not part of the international collection of law firms or juro colectivos, in most cases, you can't practice law in Cuba independently. And even then, many, I have a sanctions practice, and I've advised companies that look at that market and other high-risk markets, such as Iran, when they want to sell food, medical supplies. They're shocked. The general counsels of these companies are shocked to learn that they can't just hire any lawyer they want. They need to work with a lawyer picked for them outside, within that system. If you want to work with an independent lawyer, you can't. You can try and work with them, but they are not authorized to give you legal advice, if you will. So, and even when you work within that system, there's certain biases that are not free. There's always read within the construct of the socialist system. So this concept of an independent judicial system in Cuba is not there. It's going to take a while to build. But that consensus of change has been building for a while because a lot of these lawyers have left that system. And even though you don't hear about them, they're eager to work, they're eager to practice their profession, and they want to practice their profession freely. But political change, I think, is first the essential step, and the US stands ready to help them. One other observation that I think I've picked up from my Cuban colleagues on the island who practice independently and help not only in the human rights space, but other spaces, is that they want to try and carve that space out for themselves. And while they welcome the help of the UN and the OAS and outside groups, they're pretty strident. They want a Cuba for Cubans, a national system, a sovereign system. They welcome the help, but ultimately they want it anchored within the Cuban legal system. And Marcel alluded to some of that as well, some of the constitutions, which model would be the right one. A lot of these folks are thinking about that already. And I think we need to find ways to support them and give them ideas, but ultimately give them space, because I think that's going to be helpful in the long run once the political change has manifested itself. And finally, I think it's important that we understand that the Cuban legal tradition has been overrun by the Communist Party. The law schools in Cuba, a lot of people do not know this, were created by the Ministry of Intelligence, especially after the 70s. And a lot of the people who went into those law schools were people who were the ideologically correct people, people who believed in that system, who were the vanguard of this party, and it was done on purpose. They were training lawyers a certain way, to think a certain way, and they're not accustomed necessarily to what we would think is the customary legal tradition out in the West. But there is a reawakening there, and I think there's a lot of independent lawyers practicing in Cuba outside the system, in the margins. But the law schools themselves, they need to be changed, and that's up to the Cuban people to decide too. But there will be challenges there, and we've seen this in other countries. I've worked with lawyers in Iran. I've worked with lawyers in places like Nicaragua. I've worked with lawyers in places that the legal tradition, the rule of law tradition was non-existent or weak. And they're eager for change, but they ultimately need the support. And they will tell you that we need friends on the outside to come in here, not tell them what to do. And I want to underscore that I think something in Cuba that's very important, and that Proyecto Emilia by our good friend, Dr. Oscar Elias Bisset's project makes clear in Proyecto Emilia, is that sovereignty is key to this process, and a tradition that sprouts from that, a legal tradition that sprouts from that, maybe from a constitutional assembly in Cuba, could be one way to remedy a lot of that, but it will be a long-term process. It's not going to happen overnight. We're not going to have, I don't believe, a bar that'll be ready to go as soon as the transition begins. We're going to have to build that bar and give our friends in Cuba support, again, if they want it. So I think it's important that we have these type of conversations and interactions with our friends on the island, our friends in Europe who've gone through this, because the roots, the seeds are being sowed. There is an excellent group of people that I've been honored to work with in Cuba on the margins of the legal profession. And I think they are ready and eager and willing to do more. And I hope that we can stand with them when the time comes, if that time comes in our lifetime, that we can help rebuild a country devastated by communism.
Thank you very much. I certainly hope the time will come, and almost believe the time is coming. Second on my list is Jose Gabilondo, professor of law at Florida International University. So Jose, you have floor.
Well, first of all, I want to thank you for including me in this event. I really appreciate it. I echo a lot of what's been said. I want to make a couple of observations. I know that we use democracy as a proxy for the kinds of values that we're talking about, but I think we mean more than just democracy. I think we mean something that Martin got to a little at the beginning when he talked about what I think of as rights-based liberalism. That's really the framework that we're looking for. Cuba may have democratic mechanisms. It's not a rights-based liberal system. Now, why I think it's important to point that out is what democracy isn't a reliable source of rights. Democracy is a right. It involves the exercise of rights, but you can't look to the masses to protect your rights, especially if you're in a minority situation. And so that's why I really echo what's been said of an independent judiciary. As I see it, being organized in the being raised in the United States, we have two sources of rights and legitimacy: democracy, people, the masses, and then you have these unelected, anti-democratic federal judges who are there to protect individuals when the crowd gets it wrong. And I think in terms of foreign investments, I think Martin was saying something about foreign investment. I think foreign investors care more about an independent judiciary that will enforce contracts than they do about democracy. Now, that's just an aside. So I just wanted, so what I think the goal is to talk about a constitutional democracy, rights-based liberalism, and to recognize that that if you like rights, if what you like about the United States is its Bill of Rights, you have to recognize how anti-democratic they can be, and realize, oh, you need a referee. And in this country, it's a federal judiciary. Now, some of you may be, which I think is the most extraordinary part of this country. And also, there's a recent debate about whether the federal judiciary is at risk of becoming politicized. And I mention that because you can't take these institutions for granted. They change, you can lose them. They do require permanent vigilance. And so, it's a constant project. And again, I think just what has really worked, I think, about the United States is our system presumes disagreement, contention, a permanent state of conflict that requires some sort of resolution. And I think that that's a useful place to begin, because and I think the framers were really good at that. They assumed that there would be conflict. So how do we organize the world given the conflict? And I think that's that's not a very romantic idea about society, but I think it's a very practical one. So I really liked what Professor Perdomo said about the difficulty of creating a rule of law. You can't really create it. I love what when he talked about magic legalism. I think we sometimes think, oh, this has worked in the United States. Let's just go make the judges in Cuba independent. But for the reasons that he said, that will only work if you have education, a culture, a larger framework. I once saw someone from, I forget his name, he works with the church in Cuba, and he said, what's happened in Cuba is ontologico. It's the being of people has changed. It's at that level. And so how do you intervene in that? That's more complicated. Now, I just want to make a couple of observations, because I think that the 2019 Constitutional Convention took small steps. And I wouldn't call it even a quasi-liberal process, but it was better than the past. And why I think it was is because civil society spoke up more. I just wrote an article looking particularly at the question about marriage. And what was very interesting about the marriage debate is that civil society was in a state of contention. They couldn't agree. And I thought that was interesting and productive. Now, as you probably know, the Communist Party promoted a constitution that included the right of gay marriage, and churches basically objected. And in the end, it wasn't included, and it's been postponed for a referendum. Now, personally, I would have favored more, a broader notion of marriage rights. But I thought it was a good exercise in terms of civil society speaking up and in one way or another trumping the will of the Communist Party. So I thought from that point of view, it was an interesting process. And the final thing is I really appreciate the qualified way that people are articulating their hopes for Cuba. Like Martin said, this isn't a plan for a regime change. And I think that's very good. I think it's very good to be respectful like that, especially if what you want to do is promote rule of law, because you want to act within the culture of rule of law. So anyway, I'll stop there, and I look forward to any comments that if any of you might have.
Thank you very much. What I hear now is an interesting tension, but I would say productive tension between, let's say, emphasis on Cuban sovereignty, that Cubans really want to do things as they want to do things, and then I would say international standards, both of democracy or international human rights obligations, obligations under international law. But anyways, now I would like to ask Santiago Alpizar to make his comment. Santiago is Cuba Demanda activist, and he's a very experienced Cuban lawyer. So please, Santiago, you have the floor.
Thank you, Martin. Thank you for the invitation, and thank you for having me on this informal discussion about Cuba. As Martin mentioned, we created a project. The project is called Cuba Demanda. We are basically two lawyers, two former lawyers in Cuba, my friend Nardo Fernandez and me, that create this project to identify legal matters and issues in Cuba that can be brought into the discussion tribunals and the Cuban judiciary through the present law for Cuba. We are working in two different stages. One is the international stage and the other one is the national stage, which is inside Cuba. And we have proposed internationally that the Cuban living, for instance, in Europe that have obtained double citizenship participate on the political arena of this country where they are and try to complain against the implementation of the political dialogue and cooperation agreement between the European Union and Cuba, emphasizing what are the violations of the human rights in Cuba that are not allowed, in my opinion, this dealing commercially with Cuba on the basis that Cuba is a communist country, especially now that the European Union has equalized the Nazis and the communists. There is an issue that we need to bring into discussion all the time and complain against any dealing with a communist country that is equal to with an ideology of totalitarianism that is equal to the Nazis, a very bad situation that the Europeans suffered for many times. And it's now that the communists have created more havoc in the country where they are being rooted than the Nazis itself. We also have proposed to the United States government using the General Law of Foreign Trade and Competition of 1998, that the United States can sanction Cuba as a country that manipulate its national currency because they had imposed a 10% tax since 2004 on the central bank to all the money that came in Cuba, especially from the United States. They are taxed the dollars in a 10% artificial value that I believe is a manipulation of the Cuban currency. And that one should be corrected through additional sanctions to Cuba, considering like the United government has considered Chinese as a manipulation of the national currency. In the national arena, Cuba Demanda has obtained certain triumph, I believe, we say though, especially against the Cuban Ministry of Education, where we are obtained writing complaints from my office, signing by me and the parents of Cuban children have been abused in the school. We are able to fire those teachers that are promoting indoctrination and especially abuse against children, people that are being dissenters and oppositors in Cuba. We had the Vice Ministry of Education in Cuba to go to the little town in Holguin to explain the school of a little child that was abused, that no such as abuse can be done based exactly on the Cuban legal system, that they had what they call the Code of Youth and Children, and based on that particular articulation, we were able to first that the teacher who was abused was fired, and the children was protected from that point on. I know that one is very useful for Jason Poblet, that I believe he is currently helping a huge family in Cuba that have been subject to that kind of discrimination against their religion and the practice of their religion, and they believe through the children in the Cuban education system. So we are ready to help you out, Paulette, on that issue. No question whatsoever.
Thank you, Santiago. We look forward to working together again. Thank you.
Sure. Also, we also believe that Cuban people have the right to implement or use the power of the procedural civil code in Cuba that had the right to file complaints against people who do this act of repudiation in their neighborhood. That one is a protection that is considered on the current Cuban law that is possible to do, and we sometimes have support those complaints, and some of them have been successfully terminated with the act of repudiation in some instances. We also believe that we still have the opportunity to make change in the Cuban current constitution through the all legal, through the new constitution that requires that 50,000 signatures of voters can be made change on the old constitution. I know that the constitution also provides for the possibility of the Cuban communist system, but if we obtain these 50,000 signatures, along with the international pressure and insistence that the international covenant of civil rights and political rights have been adopted in Cuba, we can create a legal frame for the transition in Cuba. That's basically the principal objective of our project, which is not a foundation, it's just a little project. And we are working with all group of the opposition in Cuba. We have been helping on PACU. We have been involved actively in the case of Jose Daniel Ferrer. We have been supporting the Coco Fariña and Fantu in Las Villas, where we are from. My friend is from Sabana Grande, I'm from Placeta. We are very close to Coco Fariña, which I know from many years when I practiced law in Cuba. So there is an opportunity that we need to exploit, creating these numerous complaints against the Cuban government through their own law that recently have been instructed, and that the possibility to claim for damages against their own agents and people who are representing the Cuban government in the Cuban society.
Santiago, thank you very much. It was great, and I really appreciate our communication in the past couple of years. Now I would like to ask Marcel just to change the hat for a moment and step in as a participant in this very interesting discussion. Marcel.
Well, I'll say a couple of things. I mean, I really wanted to hear Pavel, but I'll jump in to comment on a couple of issues that have been commented so far. Perhaps after Pavel's presentation, we can engage in a little bit more back and forth discussion. But on Professor Gabilondo's comments, I've got four specific comments to that. Number one, I do agree. Basic rights are the key, which is why whichever way the transition works, the very first step is to guarantee certain basic rights. Those are those basic rights are the ones that guarantee democracy. Democracy doesn't guarantee the basic rights. It's the other way around. So those have to come in first, but it is a process. The basic rights give you democracy. Democracy gives you the legitimacy to govern. Under Western philosophy, Cuba is a Western country, and that's been our tradition for a Republican tradition. It's why specifically, and it's unfair, there's nobody here from Cuba Decide, but why Cuba Decide, even though it has some great people, it's a legally flawed project, because it basically wants a referendum on whether or not we want to remain in a totalitarian system, and whether or not we want to respect individual rights. My rights do not depend on the majority. If the majority decides we want to continue with communism, I can't recognize that, because they have no right to vote on my individual rights. So that is key. On the issue of whether it's already an ontological project, something cultural, and it's beyond simply something that we can do and promote. I disagree. I think that the same thing was said in Eastern Europe before the collapse of the Soviet Union. In fact, I always allude to one of Havel's own play, where protest, where the conversation between the two characters, one of them is saying to the dissidents, why do you even bother? This society has been changed permanently and forever. It's not just a legal, it's not just a political, but he basically alluded to the morality of society has been lost. And the fact is that, yes, there's been some changes in demographic changes in Cuba, of course, but that is minimal in its effect compared to the effect of a totalitarian system of government on the population. Whether it's communism or fascism, totalitarian systems bring out the worst in human beings. They bring out, people are very easy to abandon moral and ethical codes and simply go after their own self-preservation, even if that means specifically violating norms of morality. And lastly, on the issue of the 2019 Constitution, I'm a big believer in the philosophical context of the right to govern comes from the authority given by the governed. That's more of a decree than a constitution. It was not subject to any ratification, democratic ratification. Civil society did not truly participate. I mean, we work with every single civil society organization that is truly independent of the government. None of them were asked. In fact, they were prohibited from participating. The government, when you have a totalitarian government, you have to understand that there's a lot of organizations that the government will call civil society, but that are really, in and of themselves, instruments of the state. The Cuban Red Cross is an instrument of the Cuban state, and so forth. So it's not really something that has any improvement other than to say, well, it's the same as if you're wrongfully imprisoned, by a dictatorship and they beat you every other day rather than every day, then yes, it's an improvement. But in reality, it's irrelevant. You shouldn't be in prison to begin with. And lastly, in terms of the regime change and the rule of law, this regime doesn't stand for the rule of law. This regime, working within the regime and within the system, it's an oxymoron. There is no system per se. The only law, and I'm talking about their own laws, the only law that have uniformly followed is that they do whatever the maximum leader says, regardless of what the written law is. And so there is no rule of law in Cuba, and that's why we need to work in a post-regime world to create that rule of law. Now, that doesn't mean that it will necessarily come about through forces outside of the regime. It'll probably be something similar to what happened either in Eastern Europe or even in Russia, where you've got people that are currently part of that system participating in the transition. And in fact, since there is really no army, there's limited variations of bringing about that change that do not involve the system itself desiring, or people in it desiring to change. But it's certainly not something that I think it's feasible to work within the current structure. And then lastly, for Santiago, when we're done, Santiago, what I wanted to get from you is an idea from the Cuban legal perspective as a Cuban lawyer of implementing in the transition period the communist constitution versus the 1940 constitution. Obviously staying with the communist constitution and making some adjustments during the transitional period to ensure basic rights. It's more pragmatic because it's already there. The other one gives you more long-term legitimacy, I think. But those are legitimate questions, and I really don't have a clear answer. So with that, I'll end, and hopefully.
Well, I don't know if I can answer your question right now. What is our perspective? I think we are on the same line that Mr. Manzano explained. If Cuba is ratified the International Covenant of Civil Rights and political and civil rights, they are obliged to open the society to open for a discussion, and they will be obliged to register new political parties, and that will be, I believe, the basis for the transition. And immediately after that, we need to make a convention for the new constitution. I don't believe the current constitution would be a legal frame for the future of Cuba, and I don't believe either that the 1940 constitution would be the right one for Cuba at this point. It should be something that would be brand new, open to the discussion among all factors of the society, and something new will be born as a legal frame for our future in Cuba.
Okay, thank you very much. And finally, Pavel Telička, I really apologize to you that we kept you waiting for so long time. So now we'll hear important outside perspective, partner person from Prague, also representing the European perspective on Cuban things. So please, Pavel Telička, give us your opinion.
Martin, I was only happy to be patient and to listen to all of you. I'm outside Prague, in a forest. It's evening here, and it's a good time and good atmosphere to absorb, ideas from people that, unlike me, are able to live or to travel to Cuba. And as you know, unfortunately, I've never been to Cuba, and I'm not sure I will ever be allowed to go to Cuba before the regime changes. So I'm not geographically most distant, but also in this context. Anyway, just a few remarks from my side. I'll probably start from the moment when we have a change in Cuba. And I leave aside how this change has occurred. Why do I say that? Because obviously a lot will have to happen in the early days of, let's say, newly established democracy, however we define it, and the clock will be ticking, and there won't be that much time. And I think that, honestly, it would be illusionary to expect that, with all due respect to all the capacity that the Cubans have at home, to all the capacity, knowledge, experience which lies with Cubans of the island, to expect that things could evolve without some kind of assistance, and I would say even intervention from, let's say, Cuba's partners. I mean, Martin, you remember it very well. You were much more involved. You were involved in those days in the Czech Republic or in Czechoslovakia at the time. And if we say today that we still have a little bit of, let's say, the burden of communism 30 years after the Velvet Revolution, I mean, of course, in 1989, 1990, we were far from ready to cope with all the changes which were to occur, legal, economic, social, and others, on our own. So that's, I needed to comment on that. I leave aside, of course, whether it should be this or that constitution. I would probably dare to say, or to put a word in favor of a very quick change to the communist existing constitution on, let's say, dismantling the obstacles to, let's say, the first period of democratization in Cuba. But again, it's a choice for the Cubans, of course, when this moment arrives. Now, let me switch in time respect to today. Of course, from a European law point of view, I can say very little because we have no instruments, of course, now you deal with Cuba. We have no jurisdiction, but we do have a bilateral agreement on political dialogue and cooperation. And I need to say that I don't find the agreement good. In fact, if you look into the content of the agreement, you can see basically no article with a commitment, an obligation just for the Cuban side. So all is written in plural, or let's say it's a question of the two parties supporting something. But I think it would be absolutely wrong, as much as it has been criticized by let's say, Cuban friends, to drop the idea that we could not use the agreement on issues like the new constitution. And I think that we can make this linkage. So if without the relevant provisions being, let's say, contributive in the agreement, but I think that in the political dialogue, we can come analyze the change of the constitution. By the way, one side remark, of course, there are some positives in the new constitution, but all those positives are only the ones which didn't really, which really were quite cheap from the regime to make, while at the same time, they have tightened the grip. And I think that we can use that agreement by highlighting the issues that, in which we have this negative development, and clearly make it clear this is something that we will put an emphasis on and we want to work on. And I think that by doing that, we will be preparing the ground for some kind of intervention or assistance while the regime, once the regime will fall, to have the issues identified and to have concrete ideas floating already in the society, how that can be done. I think that it's a question maybe of several meetings of the parliament to deal with that. So I would say we need to apply and implement the conditionality. We need to do it now, but I'm afraid we will have to do it also once the regime will fall, because the society, with all due respect, won't be ready for it. There will be a need for something that I would call twinning in the process, whether it's from the US, from the EU, I leave aside. Now, I don't want to speak for too long, especially bearing in mind that I'm the least, let's say, engaged in Cuban affairs. I could talk for hours on other aspects of the development in Cuba and our relations with Cuba, but those would be the points I just wanted to emphasize. Thank you.
Pavel, thank you very much. I hope I will be able to see you in Prague during the summer so that we can plan our activities in this context for the future, because times are changing. I'm watching
Martin, you will have to have a COVID negative test, otherwise I'm not ready to meet you.
I will try to do my best to be on that side. But anyways, we still have a couple of minutes. Pavel, stay online, and I would love to ask all the participants if they have something to say reacting to what they just have heard. Please, welcome to do that. I have no order of speakers, but whoever wants to say something, please do it now.
Yeah, just briefly jumping in and talking a little bit about what the Cuban people may need in the future. I think one of the things I've seen in transitions, just two quick points. One involves transition justice, which we haven't talked much about, but a lot of the transitional justice and what that will look like, I think, is important. And it's been studied quite a bit. And a lot of that, of course, will be up to the Cuban people, hopefully in a parliament, to make those decisions, decide how that will happen. And ultimately, I go into the second part of this about what is the role of outside groups and organizations. And the one thing I hope for the people of Cuba, who have struggled as a nation with the issue of sovereignty, frankly, since the very beginning of the Republic in 1902, is that they be afforded space, and that organizations such as the OAS and others try not to impose on them things like they did in Guatemala, like CICIG and these other good sounding organizations that in reality are sovereignty eroding organizations that do not allow the culture, the people, the nation to sprout up. And Cuba, coming out of this very difficult period, is going to need the help, if they ask for it, of people, nations, and others who are willing to support them in their journey to try to restore sovereignty, because they don't have it. They are a client state of Russia, to a lesser extent China. And if we have those two powers meddling in the hemisphere, not only in Cuba, but in Venezuela and Nicaragua and other places, but we're talking about Cuba right now, they need time. They need time to, as Pavel was saying, to assimilate this new liberty and create a system, I hope, that will respect fundamental rights in a way that they believe best protects them, like property rights, individual rights. And there are people there who think that way. I think it's a lot more common than folks think. Communism has not managed to obliterate that sort of thinking. And I hope that we work with those people who can ask for that type of help and not impose on them things that have done great damage to Nicaragua, to Guatemala, to Honduras and other places, because the Cuban people deserve a free nation once and for all. And having that rule of law will eventually develop, but we have to be there to kind of guide them if they want that help.
Can I just follow up on that very briefly, Martina, if it's okay? I basically agree with what has just been said, because I mean, this is the country of Cubans and they will regain sovereignty. And anyway, the first challenges and the first steps, the first decisions, the first laws, all those will be up to the Cubans. But I think that, at least with my personal experience of someone that has negotiated Czech membership in the European Union, I need to say that the enthusiasm, when you overcome all the barriers, hurdles, and so on, also vanishes in time. At the same time, you still have, you know, the judiciary, which will be communist or just post-communist. You will have a lot of influence of the old guard, so to say. And I think that there is a need for what you have said, an assistance, and of course it cannot be imposed. But I think it's fair to say, you provide the Cubans with a certain vision, with a certain, let's say, light at the end of the tunnel, and see the choice. Yeah, and they should decide what the choice is. But if you opt for A, which is really integration in the democratic world, what new agreements and investments, so on, it's also something that you need to do. It works very well in terms of this, let's say, external pressure that you put on yourself, you work with it, also counter, let's say, the old forces, which will not be easy to beat, you know, in short time. So just in addition to that, but I agree very much that it has to be an assistance, guidance based on their will, but with a little bit of pressure and, you know, also conditionality, because this mixture usually works.
Well, I just wanted to respond to something that Martin said. When I said that what has happened in Cuba is ontological, I didn't mean to say that change wasn't possible. I just meant that you have to keep an open mind about where change might come. And it might not come, law might be the after effect of a process that happens, because how do you get people to demand and expect what's unimaginable for them? How do you get people to do that? To feel like they want it and they're going to get it and they're entitled? That could happen, I don't know, a book, a movie, an event. I don't know where it will come. And I think that's one reason why the Cuban government has always been so paranoid about controlling content, because maybe a movie could change, you know, could start a movement. Who knows? That's what people are like. So I mean, I just wanted to say that, and so that you don't know where it will come from.
One thing I wanted to say in regards to that, and it's a perfect segue to the discussion that Jason and Pavel were just having. Yes, you're right. We don't know where it could come from. And if it does come from the most democratic of sources, in a Boris Yeltsin type of moment, as it happened in Russia, it would be a moment, because you then have from organized forces, where it be different factions within the government, the ones that want to, let's say the Putin types do not want to change, and the Yeltsins that do want to take the opportunity to create democratic change and position themselves as the Havel or as the democratic leader. And I do think ultimately, and this is just a personal belief, that the key for a democratic leader to emerge is going to be an affiliation between someone, particularly within the armed part of the government, and independent opposition groups. So they have the international legitimacy of the dissidents and human rights group, but they have the ability to control at least a portion of the military. And that's sort of the formula, whether the spark is popular unrest, Yeltsin style, or whether it's decision that someone makes or coup, whichever way it happens. The key then goes back to this issue: what happens with the organized groups? And now that leads me into this discussion of sovereignty and international role in Cuba. And because in Cuba we have a system a little bit similar to the German system, in that it's not simply the relatively defenseless human rights groups that only have their moral standing and the military. You also have a powerful nation on earth, 90 miles away, whose policies will have a direct impact, and you have a Cuban American community that happens to be in a state that determines presidential elections, and which happens to have the luck that any lobbyist would ever like to have, which is you really care passionately about an issue that the rest of the U.S., more or less cares about, but doesn't really. So therefore, your voice on the issue becomes the national policy for the most part, and particularly for in the last few elections that has been determined. So when you have that role of Cuban Americans that are not necessarily seen as an outside external force, but rather an ally of one of the domestic forces, whichever, and whoever that might be at that time, I think you have a situation where without eroding sovereignty, because it's part of the national family, you will have players, whoever aligns with Cuban American community, that will have the ability to enforce U.S. policy, and that will have a huge effect. And U.S. policy, specifically designed by Cuban Americans, including Mr. Poblete, who was part of the drafting of the Helms-Burton Law, specifically saying that the things that need to happen, which are basically what we have been discussing as the core individual rights, freedom of the press, freedom of association, the release of the political prisoners, and the things that you need to do to be able to get to that point where you have an elected constitutional assembly. And hopefully, one of the projects that we're working on in this Cuban Marshall Plan is that that policy can be amended by an addition, say, and if you do those things, not only will the sanctions be removed, but you have an economic aid package, therefore making it even more enticing to do so.
So thank you for your remarks. And I still believe that maybe Santiago or Ofelia want to add something from their perspectives, and then I will close it up.
If you allow me, Martin, I would like to make a remark regarding something that Professor Gabilondo mentioned, which is the Cuban government control about content. So, and I also to say that they are trying to control unsuccessfully access to, especially social media. Social media is right now a winning struggle for the opposition and dissident. We are we, the Cuban people, have created a very enthusiastic activist through the social media. That's a winning moment. And there are so many people rallying around ideas and groups that are fighting a good fight in small towns, in every aspect of the society, criticizing and putting in perspective what are the Cuban people needs are and what is the aspiration of the Cuban people. They are loose social media. The government has no control whatsoever, and we need to support these social media activists. That are being taken by Rosa Maria through Cuba the City. We say Mr. Eliezer Avila and Somos Más, not to mention other people like Otaola, who have been rallying a lot of people behind him and expressing the true opinion of the Cuban people about what they expecting of the future of the country. So we are to be very supportive to not lose the access to the social media, which is right now the major confrontation that the major battle that the people of Cuba are fighting against the totalitarian regime.
Ophelia, are you still, Santiago, thank you very much. Ophelia, are you still there?
Yes, I am, Professor.
Please, do you want to say something from your perspective to this very interesting discussion?
Sure, yes. The only thing I would like to add is that obviously as a Venezuelan hearing all of this about Cuba, I feel as though you could be talking about Venezuela as well. The only major difference I see from the legal point of view is that obviously the constitution in Cuba is blatantly talking about communism and about a single party system, which is not the case in Venezuela. You can see that opposition parties and legal scholars in Venezuela cling to the 1999 constitution because it was enacted in the very early days of Chavismo. And so it still speaks about a democratic organization of the state. It still speaks about political parties and free competition for power. And so the main difference that I see is that in our case, the problem is not so much in the constitution as much as it is in its breach and its violation, and about having it actually be applied by all legal operators and the society as a whole. Obviously, we do have pieces of legislation and laws that are very problematic that have been enacted especially by the National Assembly when it was controlled by Chavismo. And you also have very politicized courts which have changed the meaning not only of the Constitution but of the laws. I actually published an op-ed today in Global Americans with Professor Frank Mora, which speaks about the conditions that need to be met in order for a transitional justice process to be successful in Venezuela. And one of them is the renewal of the judiciary, of all judges and prosecutors who either are loyal to the regime or stakeholders in its survival or have business contracts with the regime. So it's not about only reforming the legal instruments in themselves, but the whole legal system, including its operators. So I just wanted to point out that little difference between, Cuba and Venezuela. But, otherwise, I hear you guys, and I think you could be very well speaking about our country as well. Thank you for your contributions.
So I would like to thank to everybody, first of all, to Marcel Felipe, Director of Partnering Organization in this project, Ideas for Cuba. I believe that it has been a rather beginning of conversation that I would say conclusion of it. We will do much more just to attract the attention of everybody who has his or her heart and mind on the right side, which means wishing to Cubans to finally arrive at democracy and obviously rule of law, independence of judiciary, and all these components of free society. And also, I can only say that we Czechs, and I think Pavel Telička in this context, are on your side. And I can say as director of Václav Havel Program for Human Rights and Diplomacy here at Florida International University, that we will keep going on in our projects. We'll stay on track consistently in Václav Havel legacy, and we will keep our fingers crossed and wish you all the best on your difficult way, but the way from authoritarianism to democracy.